This is Barry Zalma on insurance. Today I'd like to talk about the ethical burden placed on attorneys when faced with a need to settle litigation. Settlements of litigation, whether funded by an insurance company or not, raise ethical issues that all parties and their attorneys must deal with before the settlement is effected. The decision to settle belongs to the plaintiff. This is especially important in cases with multiple parties and multiple attorneys. The Third U.S. Circuit Court of Appeals revived a proposed class action suit against a group of attorneys from southern states, brought by more than 2,600 former clients from northern states, who said they were cheated out of their fair share of $400 million in asbestos personal injury settlements in the Mississippi state courts when the attorneys gave larger payouts to southern plaintiffs. The northern plaintiffs claimed that their share was reduced because the southern attorneys wanted to allocate a greater percentage of aggregate settlements to southerners in order to minimize the percentages paid to the northern plaintiffs' local counsel. Basically, one group of lawyers tried to cheat another group of lawyers. The plaintiffs in Huber v. Taylor, a Third Circuit decision from 2006, were steel workers from Pennsylvania, Ohio, and Indiana, who joined a massive Mississippi asbestos suit. The defendants were attorneys from Mississippi, North Carolina, and Texas. The suit alleged that the northern plaintiffs were never made aware of a complex series of agreements between and among the attorneys that they say ultimately led to their receiving smaller payouts than southern plaintiffs. The northern plaintiffs had all retained attorneys in their home states, referred to in the cases local counsel, who had in turn struck deals with a Texas attorney who served as co-counsel. According to the suit, by cheating the northern plaintiffs of their fair share, the southern attorneys saved more than $10 million that would have been paid to the northern client's local counsel. Reversing a lower court's decision that dismissed the suit, Senior U.S. Circuit Judge Jane R. Roth issued a stern lecture to attorneys about the duty of loyalty. Quote, "We are embarrassed to have to explain a matter so elementary to the legal profession that it speaks for itself. All attorneys in a co-counsel relationship individually owe each and every client the duty of loyalty. For it to be otherwise is inconceivable." Close quote. Judge Roth made clear that the fiduciary duty that an attorney owes clients is not a matter to be taken lightly. The duty may not be dispensed with or modified simply for the convenience and economies of a class action. Among the conditions imposed on all attorneys is the ethical obligation to give clients full and meaningful disclosure of conflicts of interest so that they may decide if the representation is in their best interest, and of the terms of proposed settlement agreements as if it is the client's, not the attorney's, decision whether to settle a case. Under Texas law, a client need not prove actual damages in order to obtain forfeiture of an attorney's fee for the attorney's breach of a fiduciary duty to the client. But Judge Ross found there was evidence that the settlements were, in fact, aggregate, and that the plaintiffs may have a valid claim under Texas law for breach of the fiduciary duty that could entitle them to a disgorgement of the southern attorney's fees. That would hurt. While North Carolina does not recognize a alone claim for breach of fiduciary duty. It never has recognized a claim to apply to an attorney acting within the scope of his or her representation of a client. That duty, of course, does not apply to other parties to the suit. Under American Bar Association Model Rule of Ethics 4.1, an attorney representing a party may not make a false representation of fact. However, an attorney may, as part of negotiation, refrain from disclosing a client's negotiation goals or willingness to compromise. If attorneys were required to disclose their client's goals or willingness to compromise, it would be difficult to resolve any lawsuit any more than one can win a game of poker if all of the cards are made visible to all the other parties. When negotiating with the other side, it is appropriate and common to include what is sometimes called puffing. Puffing is generally not considered a false statement of material fact under the ABA rules. The ABA Ethics Committee distinguished ABA Rule 4.1a, which prohibits an attorney in the course of representing a client from knowingly making a false statement of material fact to a third party, from ABA Model Rule 3.3, which applies to statements made to a tribunal, such as in a binding arbitration, and ABA Model Rule 8.4, which applies in general to conduct involving dishonesty, fraud, deceit, or misrepresentation. The ABA Committee noted that Rule 8.4c does not hold attorneys to a higher degree of truthfulness than Rule 4.1. The committee further emphasized that it is never acceptable, never, to lie to a judge. If a judge were to act about limits of settlement authority given to an attorney by a client, the attorney may decline to answer, but may not answer falsely. By contrast, the committee concluded that posturing and puffery are acceptable between opposing attorneys or with a neutral mediator. An attorney may downplay the client's desire to settle or overstate the strengths and understate the weaknesses of the client's case. Nonetheless, an attorney may not misstate facts, such as knowingly misstating applicable insurance policy limits. It is well-settled law, regardless of jurisdiction, that attorneys owe their clients a fiduciary duty. This duty is not to be taken lightly. It may not be dispensed with or modified simply for the convenience and economy of a class action. There is no worse conduct that a lawyer can commit than to cheat his or her own client. In the case of the various fee-splitting situations, lawyers who failed to act fairly and in good faith to their own clients and to their co-counsel have found themselves charged not only with negligence or breach of fiduciary duty, but with criminal conduct. And some have actually gone to prison and lost their license to practice law. This was said of a lawyer who was known to be one of the most famous tort lawyers in the country, who had resolved multiple million-dollar cases involving asbestos, only to find that when he cheated his co-counsel out of their appropriate fees and then tried to bribe a judge to fulfill his lack of honesty and good faith to his co-counsel, found himself arrested, tried, and convicted of fraud, and found himself spending a good deal of time in the Gray Bar Hotel, the federal prison. This video was adapted from my book, Selma on Insurance Claims, Part 107, 3rd edition, which is available as a Kindle book, a paperback, and a hardcover from Amazon.com. Please subscribe to my YouTube channel and my Rumble channel, clicking on the like and the Rumble buttons as you do. And please also subscribe to my blog and my Substack publication, which all are free, cost you nothing. And we will probably be posting on Substack a small charge for bigger and better and more useful or more entertaining publications. Thank you for your attention.